Welcome to Within the Frame, where we bring the most pressing issues across the globe into focus. I'm Kim Mok-yeon. The impeachment trial of President Yoon Suk Yeol is entering a decisive phase, with the Constitutional Court set to conclude its hearings on February 25th. Over 10 sessions, the court has examined key testimonies, including those of Prime Minister Han Duck-soo and former National Intelligence Service Deputy Director Jang-won, who presented a controversial memo allegedly listing politicians for arrest. The hearings have sparked intense debate over procedural flaws in cabinet meetings and President Yoon's role in past emergency measures. Meanwhile, Yoon's legal battles extend beyond impeachment as he faces a criminal trial on insurrection charges. Now, his legal team argues that his detention is unjust, adding another layer of complexity to his presidency. For a deeper analysis of the situation, we are joined by attorney An Jun-sung here in the studio with us. Welcome. And also joining us online is Lee Hyun, Dean and Professor of Law at Handong International Law School. Great to have you again, Professor.
Thanks for having me on the program.
So let us start with Mr. An. The 10th hearing of President Yoon Suk Yeol's impeachment trial took place yesterday, and previously the President Yoon's side has requested for a postponement, citing both criminal trial for insurrection charges and the impeachment hearing were scheduled at the same day, but the court has rejected this request. Before we get into the details of the hearing, could you tell us what was the reasoning behind the court's decision?
Yes, the Korean Constitutional Court came with several reasons. Most importantly, I think that the court found that there was a sufficient time for the court procedures on the same day. For example, there was the preliminary hearing for the criminal case, which was set for 10 a.m. And also there was the 10th hearing for the impeachment trial, which was set for 2 p.m. So KCC found that that's kind of decided 4-hour difference, two events is sufficient, including maybe lunchtime, perhaps travel time between two different courts. And actually, the preliminary hearing for criminal trial took only 13 minutes, actually. So I guess in that respect, the court was right about it. And also, there was a court mentioned that there's the reason they reject the postponement, request is that one of the reasons is that in the best interest of defendant, because on that day, the three witnesses which has been requested by the defendant side were supposed to be testified. So if they reschedule it, maybe it's not easy to get everybody on the same in the trial day. So that's why they say come up with the idea rejection.
Right, so they considered a lot of details into the fact. But the 10th hearing, now let's go into the details. Prime Minister Han Duck-soo has testified and requested as a witness by President Yoon's team, but he consistently claimed that there were procedural flaws in past cabinet meetings. Professor Lee, with the direction of his comments, why do you think President Yoon's team chose to summon him as a witness? And also, what kind of impact do you think his testimony would have on the impeachment trial?
Well, I think the president's side chose to have the prime minister testify was basically to demonstrate that there was a justifiable basis for declaring martial law. So if you looked at the line of questioning from President Yoon's lawyers, they were basically trying to sort of identify situations where the National Assembly was basically being obstructionist when it comes to the running of state affairs. So, the accusation here basically is that the National Assembly, and from the Prime Minister's perspective, basically was trying to prevent the legislative agendas to be sort of put forward. So the Prime Minister and the questions that were being asked, particularly in relationship to, let's say, the impeachment of other state council members, various ministers that would effectively, basically hamper the work of the state council. Moreover, with respect to certain kinds of legislation as well, that the accusation here is that the National Assembly, being controlled by the Democratic Party, basically did not go forward with a number of the important things that the government was trying to produce in terms of legislation. So I think actually that was probably more of a political kind of a move in terms of the testimony offered by the Prime Minister to I think to basically appeal to the public, saying that the National Assembly was dysfunctional essentially because it was being dominated by the Democratic Party. But in terms of the actual testimony on the other side, the National Assembly I think was who are prosecuting this case, basically they were trying to show that the Prime Minister agreed that the whole process by declaring martial law, the procedures, which normally you have to have the State Council deliberate before the President can make a martial law declaration, that there were basically irregularities with respect to the State Council meeting. So the Prime Minister's testimony here, while I think President Yoon's side was trying to portray some sympathy for his position, I think in some sense may have backfired, because the Prime Minister, even though he did make a declaration that there was some irregularities with the State Council meeting before martial law was declared, that I think the opinion seems to be that maybe this was not done in the most efficient and most legal way possible.
Mm-hmm. Now, another point to talk about during the session yesterday was Jang-won, former first deputy director of the intelligence agency, who's a key figure in determining whether President Yoon actually ordered the arrest of politicians during the martial law period, appeared in court. And he presented a memo of the politician arrest list, engaged in a heated debate, which caused a heated debate with President Yoon's side. So, Mr. Han, what kind of aspects will the Constitutional Court focus in its judgment regarding the credibility of this memo?
Well, that's a very interesting question. I looked it up and what was happening and checked the actual memo. It's very interesting, the aspect there. And please note that the memo, the memo, has not been formally admitted as evidence at the court mainly because that it was allegedly drafted by someone else, third party. I think that about his assistant, not by himself. So it's not his testimony. Well, his testimony may be admissible, but the evidence produced by him, but which was allegedly made by someone else. So it's not admissible as the evidence. So I guess that's the issue, admissibility of the evidence, whether they can court will admit that evidence, right? Also, so his testimony is one thing, and the evidence, such as the memo in question, is the another. So we have to wait and see what will happen. And also, however, once again, before we talk about the admissibility, it's more like it's unlikely that court. I think that unlikely the court admit that evidence and put that memo as the evidence because of some of the problem with the allegation about who drafted. Also, there's during the procedure, I think they talk about there were more than one copies of memo, maybe more or less 4 copies, and also it was allegedly drafted by someone else. So there's a credibility issue, and the present side will, defense team will keep challenging on the credibility of the evidence. But I think that from the legal perspective, although maybe it's unlikely that court will admit that evidence, the memo as the evidence or the admissible evidence. However, I think that court might use it as a circumstantial evidence to infer to the circumstance that how the President Yoon did it, whether he did it. But it's not really showing his intent or his guilty mind. However, it can show the circumstance that there's most likely, if you see the circumstance that there was kind of pressure or even unwritten rule or something happening there, pressure or political pressure from his boss saying you have to do something. So I guess it's showing could they use it as a circumstantial evidence?
Right. So circumstantial evidence meaning they would not have it as a legal, evidence, but just help in understanding
more like
them.
Not directly proving that President Yoon ordered to do something.
It didn't directly.
And but indirectly showing that there was kind of a circumstance. He felt that he ordered me something, and someone next to me wrote it down.
Right.
So it's kind of it's not really. So but the problem here is you have to prove the intent. It's more like criminal case, right? So it's hard to prove the intent itself, but you can show the circumstance that you can infer the fact that maybe someone else might think that there's something happening there.
Right. So with a lot of things happening on the 10th hearing, now it had been concluded yesterday, and witnesses questioning in President Yoon's impeachment trial is essentially complete now. Professor Lee, do you believe the 10 hearings have provided a sufficient review of the case?
Well, I think it certainly depends on the side you're taking, but because obviously President Yoon's side will say the 10 hearings are not enough. They want the full 180 days. But I don't think that's obviously realistic here, given that the court really wants to expeditiously move this case forward. And so I think you need to sort of evaluate this question in terms of what evidence has been presented thus far, and does the court have enough to either decide to impeach or to not impeach. And I think if you sort of look at what we've heard and the evidence that's been submitted at this point, I think it seems to be that the court could make some decisive decision at this point as to determining whether or not, you know, the president engaged in acts that were impeachable. And so remember, what we're dealing here with is the constitutional sort of standard here as to whether or not the president did something that is raised to the level of some sort of constitutional liability that could justify his removal from office. And so I suspect that, you know, again, if you're on either side of the question, it does appear, though, that the court gave additional time, right? They originally were going to have only 8 hearings, and they added a couple of more hearings to accommodate, you know, the witness requests of the prime minister as well as others. And so I think the court was trying to sort of walk a fine line between, you know, obviously having a fair trial and giving the president due process, while at the same time ensuring that there was an efficient trial. So I think 10 hearings in terms of witnesses, and then you'll have a final hearing, of course, when it comes to the final arguments, as far as the final closing statements made by each side. And, you know, in comparison to the previous impeachment cases with President Moon and President Park, you know, this won't certainly get to the level of President Park's impeachment in terms of, you know, how many arguments, as well as the number of time it took in terms of reaching a decision. But in that case, of course, there were probably more complex issues, more factual assertions there. And certainly this case has been longer than President Moon's impeachment trial. So I think you're sort of finding sort of a period in between. And so I think a lot of people will judge this to be generally fair. But again, you know, if you're the defense, you obviously want as much time as you can. So I think the 10 hearings as far as witnesses, and then of course the 11th, I think there's been a sufficient amount of evidence presented at this point where the court can make a informed decision.
Right, so it really depends on which side you're in, but it's a fact that it had extended and had added some hearings to the current ones. Now, with a total of 16 witnesses, they're done testifying. Mr. An, having followed the hearings as a legal expert, which kind of testimonies do you think have had the most decisive impact on the trial's outcome?
Well, you know, as Professor Lee mentioned earlier, right? I think out of 16, you know, witnesses, I think the Prime Minister Han Duck-soo was the most decisive in many aspects. First of all, I think he was requested by the president's legal team, right? So he was supposed to be, you know, testify for him, but in reality, I think that from legal perspective, it really helped him much. Actually, maybe the other way around, I think, and because that he reaffirmed that. From that there was a procedural flaw during the cabinet meeting prior to the martial law declaration on December 3rd. So I think that's really critical. He didn't change his position at all. Although he sounds like a retracts a little bit, saying that I'm not sure whether it's legal or illegal about the formality issue, but he did say basically, I'm not in a position to make any decision or judgment call whether the cabinet meeting was properly convened or not, right? So also, I think he confirmed again that there was no consent process. Basically, all the cabinet members not attended that time all strongly disagree, and he also said that I strongly disagree with President on that matter. That's really hurt him, President Yoon very much, because more like a double-edged sword to the President Yoon's legal team, because that it really showing that he actually did it and what he meant to do. So I think this is a very serious situation. And then, yeah, so I guess what I'm seeing, and plus what happened was that there was interesting happened, President was kind of get out of the room, come back later on, because, well, he basically saying that allegedly were arguing that there was a, political issue, we don't want to get President and Prime Minister on the same courtroom at the same time, but maybe he wasn't not sure what kind of thing he testified. Han Duck-soo is very seasoned politicians. Have a decades of career, so he knows what to do, what not to do. So I guess maybe he tried to avoid the confrontation situation with him. So I guess.
Right, especially with Han Duck-soo being Yoon's witness, it also definitely dealt an impact to the situation. Now, the Constitutional Court has decided to conclude the impeachment hearings on February 25th. Professor Lee, what key issues will be addressed in the final hearing? And also, can you tell us what will be the next steps in the legal process after this?
Well, essentially, what the court, and I sort of following up on Attorney An's point about, Prime Minister Han Duck-soo's testimony, because, one of the biggest questions is, was there, a justifiable basis for declaring martial law? And then once martial law was declared, its imposition was the imposition of it and implementation of it done in a constitutionally valid way. So when it comes to this question, those really are the highlighting issues that are going to decide this case. And so with respect to just the arguments that have been presented thus far, the court's going to have to look at whether or not there was a constitutional basis and whether the procedures themselves were followed. So, on the National Assembly side, this is the prosecuting side. They're going to say that this is totally unconstitutional because when you're talking about martial law, you're talking about a national emergency, something that's akin to a war or a civil war disturbance or some sort of national emergency of the highest order that will require martial law to be declared. There was no such incident in Korea at the time. There was no war going on. North Korea was not invading. There was no internal disturbance of the magnitude that would justify that. So the National Assembly side is going to say, of course, there was no factual basis to determine this. And moreover, there was a procedural flaw with respect to how martial law was declared because the State Council did not deliberate and give its recommendation to the President. In fact, Prime Minister seemed to suggest very clearly that the State Council was kind of resisting the recommendation for making martial law, and they were trying to persuade him not to go through with it. So in that respect, I think that's going to be one of the biggest questions on that question. But then, of course, on the other hand, about the imposition and implementation, if it's found that the President had ordered National Assembly members to be arrested and dragged out of the National Assembly for the purpose of obstructing any vote towards canceling martial law, that would also be another basis for impeaching the president. So I think we're looking at the questions of the imposition, the decision to make martial law and implement it, and then how was it executed. I think that's going to be the focus of the Constitutional Court's decision as to whether or not the president should remain in office.
Right. And could you also tell us about the next steps after the hearing is held?
Absolutely. Well, once the hearings are held, of course, the court is going to have to deliberate. So we'll have final closing arguments essentially made by each side. They'll present their final viewpoints as to how this case should be resolved. And then the court will take probably about 2 weeks to deliberate and then make its final decision. And so at that point, the court will then make a public final decision as to whether or not to whether or not the impeachment should be upheld and that President then Yoon should be removed from office, or whether or not impeachment should be denied, and then he can immediately return to office. And so, the whole country, of course, will be waiting with bated breath, essentially, probably by early to mid-March, when the court will then make its final decision.
Mm-hmm. Now, let's also talk about the authority dispute case regarding acting President Choi Sang-mok's decision not to appoint Ma Eun-hyuk as a Constitutional Court justice. It's still awaiting the final date. Why hasn't the court set a final date for its ruling, Attorney An?
Yes, I think there's also a very interesting situation because if you look at the fact, go back to the timeline, and what happened was that the acting prime minister / acting president, right, and he decided not to appoint the last justice for the Korean Constitutional Court because in a way he believed that that's the way to helping his boss during the litigation. However, what happened was that at this moment things have changed. Right. So what happened was that now they're using the Yoon's legal team using that situation for their advantage, try to, delay the process delay, right? So what happened was they want to delay it as a delay tactic, so that basically what was in the technicality issue, procedurally, if there's change of the bench in constitutional court, they supposed to have resume the process. Basically, what they do is like whoever join later have to understand what we're going on and listen to the doesn't have to be literally listen to it. They can listen to the recordings and check the evidence. That will take considerable time. So I guess that the Yoon Suk legal team tried to buy more time to delay it as much as they possible. But in reality, I don't think that, there's the ball in the constitutional court side, so they will decide what to do. And the problem was that we know that in April there were 2 justices will be retired. Mm-hmm. So if you delay anymore, there's going to be more problem. And the April. So what we try to do is they targeting to finish up everything in sometime in March before the April, so that they don't have some problem with technical issue about how many justices on the bench.
Right. So we'll have to wait until that time. Now, let's also touch upon Yoon's detention before we let you go. President Yoon Suk Yeol has now been booked on suspicion of obstructing the execution of his own detention warrant, and police say he instructed the Presidential Security Service to block investigators attempting to detain him. But as far as we know, he's a sitting president, so he's immune for these charges. Given this circumstances, what legal and political implications could this have on the ongoing legal proceedings, Professor Lee?
Right. So as you noted, according to the Korean Constitution, Article 84 provides that the president cannot be charged with any criminal offense other than, insurrection or treason. And so any other crimes that the prosecution or the police are accusing him of, while he's a sitting president, he's immune from criminal prosecution. So those charges, if he remains the president, cannot be basically brought against him. So depending on the outcome of the impeachment, basically, if President Yoon is found not to be impeached and he remains in office, all of those charges that have been brought against him, again, with the exception of insurrection, can be brought forward in terms of the criminal proceedings against him. So when it comes to this question, then essentially what the prosecutors and the police are doing is they're kind of biding their time on this question and probably betting in some sense that the Constitutional Court is going to impeach the president. And so I think what you're seeing here is the strategy on part of the prosecution as well as the police that, it looks like that the president will be in fact impeached. And if he is impeached, then he loses immunity. He's removed from office. He just becomes like any ordinary Korean citizen. Now, certainly he was a president, but his immunity only extends to his official capacity as he is the president. So in this case, as we've seen in the past in Korean history, presidents have been prosecuted and put in jail. And so I think what we're going to see here politically as well as legally, we're going to see a huge seismic shock either way when it comes to whether the Constitutional Court decides either to impeach the president or to keep him in office. And so at that point, once those decisions are made, then the dominoes will then fall when it comes to the legal issues that the president is facing, with the exception of the insurrection charge, which potentially can still move forward because under the Constitution, he can be convicted of an insurrection charge.
Right. So with the latest allegations on obstruction added to the mix, we'll have to keep tabs on how these legal developments could shape the next chapter of South Korea's political landscape. We will have to conclude our discussion right here. Thank you so much, Attorney An.
Thank you.
And Professor Lee, for your insights tonight. We appreciate it.
It was my pleasure.
And that'll be all from us on Within the Frame. Be sure to tune in next time as we continue to explore the stories that matter. Until then, stay informed and engaged.